The United Nations High Commissioner for Human Rights, Navi Pillay, who has served as judge at the International Criminal Tribunal for Rwanda and as a member of the first panel of judges of the International Criminal Court, joins us today. Please welcome on stage the United Nations Commissioner for Human Rights.
President Khama, if he's arrived, Excellencies, distinguished members of this year's Justicia's Awards, ladies and gentlemen, it gives me great pleasure to address you on the eve of the Assembly of ICC States Parties. While the situation of 6 new ICC judges and the next prosecutor still lies ahead of us, the selection for the Cinema for Peace Justicia Awards has already been made. I must say that the jury has selected a very impressive cast to receive this year's Oscars in International Justice. I am particularly pleased to see that President Khama of Botswana, our guest of honor tonight, is one of the recipients. Botswana's contribution to the rule of law and accountability for serious crimes is well known. The devotees of crime novels amongst us are, of course, well acquainted with the exploits of Botswana's answer to Miss Marple or to Mr. Ocampo, Miss Precious Ramotswe and her #1 ladies detective agencies. On a more serious note, the contribution that Botswana has made to the international rule of law under the leadership of President Khama are even more notable. I applaud him in particular for his unwavering support for the International Criminal Court, which has proven to be of great relevance for our continent. In this context, we should not forget that the ICC also has African roots. When the Cold War froze all hopes of establishing an international criminal court in the immediate aftermath of the Nuremberg and Tokyo tribunals, it was African states who revived the idea of an international tribunal to try international crimes. I remember that because I was part of the struggle against apartheid, a struggle that benefited greatly from support of other African states, with Botswana and others on the front line. Apartheid South Africa tried to cover up a system based on the denial of equality in law and dignity by establishing the veneer of a so-called rule of law based on unjust laws and ordinances. African states shattered this pretense. In 1973, they moved the UN General Assembly to adopt the Convention on the Crime of Apartheid, which recognized that apartheid was nothing less than a crime against humanity. The Anti-Apartheid Convention did not stop there. It also evoked the prospect of establishing an international tribunal to try the perpetrators of international crime. African states thereby took the first step to resuscitate the intergovernmental debate that eventually led to the adoption of the Rome Statute of the International Criminal Court. Ladies and gentlemen, we tend to lose ourselves in very divisive debates on who should be brought before the ICC and who should not. Yet the Rome Statute is much more than the ICC. At its heart is the principle of complementarity. The ICC comes in only as a last line of defense against impunity when a state proves to be unwilling or unable to prosecute international crimes committed in its jurisdiction. When all states are fulfilling their responsibilities, we will no longer have to argue about whether someone should be sent to The Hague or not. It is therefore encouraging that attitudes to justice and impunity are changing across the African continent. Last week, for instance, the Economic Community of West African States and my office hosted a major conference in which ministers of justice and other delegates from all over West Africa made specific commitments aimed at ending impunity and promoting justice. Slowly but surely, a paradigm of accountability and truth is replacing the old ways of impunity and amnesia. Backroom deals on how best to forget what happened in a conflict are being replaced by national consultations where all parts of society come together to develop a shared vision of how transitional justice will look. African states are gradually equipping themselves with the legal frameworks and institutions to deal effectively with impunity for international crimes. My office will continue to provide technical assistance in this respect. In a number of countries that experienced conflict or post-electoral violence in the recent past, non-partisan commissions are busy establishing the truth about violations and laying the ground for reconciliation. Moreover, this new generation of Truth and Reconciliation Commissions is not meant to replace the prosecution of major perpetrators, but to complement it. In the very near future, the Special Court of Sierra Leone, a hybrid tribunal composed of local and international judges, is expected to hand down the judgment in its final case, the case of Charles Taylor, the first African president ever indicted for international crimes while in office. The establishment of similar hybrid tribunals is envisaged, for instance, with regard to international crimes committed in the Democratic Republic of the Congo. Beyond the criminal justice field, we are also witnessing the emergence of African regional courts, where individuals can bring human rights cases. The ECOWAS Court of Justice, for example, has distinguished itself by ruling in favor of children deprived of free primary education and women enslaved since birth. The Tribunal of the Southern African Development Community, SADC, was pursuing the same progressive path in line with its founding instruments until SADC states effectively suspended its operation. I hope that President Khama and other SADC leaders committed to human rights will ensure that the tribunal can resume its work and retains jurisdiction over individual complaints. Ladies and gentlemen, allow me to conclude by briefly addressing another issue of great relevance for our continent. When we speak of international crimes, we tend to think of crimes committed in the name of states or armed groups. Yet, corporations, especially those active in conflict areas, are sometimes behind international crimes as well. For this reason, the drafters of the Rome Statute considered a proposal that would have allowed the ICC to try corporations for international crimes. In the end, the proposal was unfortunately shelved because the details could not be ironed out in time. However, it is encouraging that an increasing number of states are establishing corporate responsibility for international crimes as they integrate the Rome Statute into their national legal orders. Under the Alien Tort Statute, the US federal courts have long afforded victims of human rights violations committed anywhere in the world a forum to bring civil liability claims. However, as we speak, a major legal battle is waging before the US Supreme Court on whether a well-known oil company can be held liable for complicity in gross human rights violations committed in the Niger Delta. The lawyers for the oil company are effectively arguing that corporations do not have any obligations under international law and could hence not be held liable under international law even if they took part in crimes against humanity, committed genocide, or traded in slaves. It is questionable whether this point of view is morally or legally tenable. There is little question that corporations, like individuals and other non-state entities, are at a minimum obligated under international law not to commit gross human rights violations that amount to international crimes. I have instructed my office to formally transmit this point of view to the US Supreme Court. Any other stance runs afoul of the basic idea of the rule of law that Thomas Fuller once summed up as follows: "Be you never so high, the law is above you." Thank you very much for your attention.